All right, boys and girls, welcome back. Another edition of Freedom Steel here. Todd Vandermeide, former NRA contract lobbyist and Illinois gun law guru. So, today's subject matter, we're going to talk about ghost guns. They've been in the news a lot. You've got two sides to this coin. You got the federal level stuff and the state level stuff. So, let's get into this. On the federal level, back in April, the Biden administration issued a new rule on frames for receivers, and it was their attempt to get at the quote 80 percenters and try to regulate that market because they did not like people manufacturing their own semi-autos. Particularly, people were, since at the time, those types of unfinished frames or receivers didn't have to go through an FFL. So in places where you had bans, people were manufacturing their own firearms. If you could not get one through the gun store, and some people just like they don't want their names on paperwork. They don't want to, the government. Oh, you have to register this, or if there's no way for them to know, they don't know you got it. There's nothing for them to know about confiscating, unless you're just doing all kinds of TikTok and YouTube videos and everything else, letting everybody know. So what you have is Congress has delegated certain powers to agencies, particularly in this case ATF, about they can. There's law that's by statute, law is defined by the court, and you have regulatory law, which Congress allegedly gives them the power to do. The problem with this is that this invokes two issues at the federal level. There's a thing called the Chevron doctrine, which was a case of Chevron versus the EPA about how far EPA could go in regulating certain things and under environmental law. So now, Chevron has typically not been applied in cases where there are criminal penalties. And Chevron says that if something is undefined, then the agency is given wide latitude to interpret what Congress says. There has been a pairing under the court recently to start shaving back on Chevron deference and giving deference to the agency. And in this last case, there was another EPA case came out of West Virginia, and we thought it was going to go to the Chevron doctrine, but they just literally ignored Chevron and brought up another piece called the major questions doctrine. And the question is the regulatory nature so big that it actually needed to be addressed by Congress and not by the agency? And that's the big thing right there. So this rule implicates both of those things, whether or not the agency has overextended its authority, gone beyond what Congress allows it to do, taken more latitude. And you see this when you have a legislative body that won't pass things. So the president uses his pen and decides to tell a regulatory agency that you're going to do more, and we're going to do this without having to go through Congress. And that's the test right now. Has ATF gone beyond what they can be legally allowed to do? And so, it's also interesting to note that in this federal regulation, they went after the commercial sales of these items, these unfinished frames or receivers. They didn't go after personal ownership. I think that somebody at the Justice Department is smart enough to know that if they get into a thing about possession, it leads them into a whole nother round of litigation, much like Heller and McDonald did about personal possession. So they stayed away from that. They didn't mandate that you had to get it serialized. They recognized that people have been building their own firearms since the founding of this nation. So I think they tried to stay within a certain set of lines, but then tried to push that as far as they can. Then you have, under Heller, you have the quote where they talked about the regulation that, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. We have not got what those conditions and qualifications are flushed out, but Heller said that some of those things were presumptively lawful. So that's probably where the Biden administration and Justice Department thought they had the most wiggle room, that they could do this under that. Now, there are a couple of cases pending down in Texas about this. You have the Vanderstock case, which is the one getting the most attention. So a manufacturer of, quote, 80% frames was, fearful of prosecution and administrative action by ATF. They filed a lawsuit. They have prevailed in a good chunk of their stuff, and now other entities and groups are asked to being let in to this litigation in order to take advantage of it. Naturally, ATF is opposing and is appealing the rulings here. But what gets interesting here is that earlier this year, within the litigation, ATF issued a new rule, or they were putting together a new in putting together this new rule. What they did is they made certain aspersions within the court. So I'm going to give a shout out here to the armed scholar, and he did a bit on this. So rather than me re-argue at everything, I'll just take it from him. So we'll go and do that right now.
It remains true that a partially complete frame or receiver alone is not a frame or receiver if it still requires performance of certain machining operations. They went on to state that accordingly, under the rule, companies that sell or distribute only unfinished frame or receiver billets or blanks, and not any associated jigs, templates, or similar tools to the same customer, are not regulated to be licensed or to mark those articles with identifying information.
So that was the pronouncement that ATF made in court, saying if it didn't come with a jig, if it didn't come with tools, and then here we are, December 27th, ATF comes out with this letter primarily addressing Glock-type striker-fired pistols and the Poly 80 lowers and all that kind of stuff. And now they're playing a game with they're playing all kinds of semantics with readily convertible to type language, or may readily be completed or assembled, restored, or otherwise converted. They're playing a lot of games with that. And I think if you look what they said in court, the real question now is, did they lie? Did they commit a perjury? Have they misrepresented everything to the court? And are there going to be sanctions, or are they in contempt? And what I think here is, I think they're going to play a game. So let's go back here. According under the rule, companies that sell or distribute only unfinished frame or receiver billets or blanks. That's what I think they're going to play around with, because reach over here. So this is a forging. This is a blank. No fire control pocket, nothing machined, no magwell broaching, nothing. This is a raw forging. In my house, this is a paperweight. That's all it's good for right now. Show and tell, paperweight. If you are going to make billet receivers, then what happens is you take this, a big old chunk of aluminum. You take that gets machined into this. So I think ATF is going to try to weasel out of this. And they're going to claim that they should not be held in contempt. They didn't lie to the court because they weren't talking about true 80% style lowers. They were saying that, hey, if you sell a forging or a true blank, these aren't regulated. That's what I think they're going to do. And we're going to, it's kind of like with the anti-gunners on semi-autos, making the argument about dangerous or unusual versus dangerous and unusual. Here, I think they're going to try to play semantics with this billets or blanks. And they're going to try to use that to, carve out as much as they can, grab as much ground as they can. Now, on the other side of things, the state sat there and took a completely different approach. What the state did was they went after the sale of unfinished frames or receivers, and as well as the possession. There are problems with the bill, but they talk about 3D printer stuff. That has problems unto itself with their definition of that. We're not getting into that just yet. When litigation comes around, then they'll find out where they screwed up. But, unfinished frame or receiver under Illinois law means any forging, casting, printing, extrusion, machine body, or similar article that has reached a stage in manufacture where it may be readily completed, assembled, or converted to be a functional firearm. Note, they are almost verbatim quoting ATF language there. Is marked or sold to the public to become or used as a frame or receiver of a functional firearm once completed, assembled, or converted. So back in, you can find websites that sell tubes that had the blueprints for a Sten or a Sterling or another type of firearm like that glued to them or etched on them. So even the question is, how far does this go with a raw piece of tubing? Inch and a half chromoly tubing is all it takes to build a Sten or a Sterling or similar tube style gun like that. We're not sure. So the bill goes on to say, it is unlawful for any person to knowingly sell, offer to sell, or transfer an unserialized, unfinished frame or receiver or unserialized firearm. There's an exception for an importer, manufacturer, or dealer on this stuff. But this right here, this language is significant. But notice on this part, possession isn't included. But transfer is, So Illinois took at it a little differently because now they're going to the end user transfer, any of that stuff. It bans the acquisition, it bans the manufacturer, it bans the sale, bans the transport of a unserialized firearm or frame, receiver, or any of that. So when we get down here, beginning 180 days after the effective date of this amendatory act of the 102nd General Assembly, it is unlawful for any person to knowingly possess or transport or to receive an unfinished frame or receiver unless it's been serialized and all that. I think they have a number of problems with this. So a couple of those problems, you've got possess and transport are two big issues. So one, you make anything, because technically right now, FFLs should not be engraving new firearms. They just shouldn't. It's, past the 180 days, whatever. I mean, there's question about that whole side of it. But transport, so if you're, say, a Wisconsin resident passing through the state of Illinois and your carry gun is a home-built Glock-style firearm, you've never had it serialized because the state of Wisconsin doesn't require you to do so, you're committing a felony. That carry gun of yours, which is perfectly legal in Wisconsin, as you're driving through the state of Illinois, is illegal in the state. And I think they've got a host of issues with these that we're going to get to as we get through all this. You've heard me talk in the past about things where, in my exchange with Representative Stoneback, about the individual within the Second Amendment. Yes, it's there under the people. And now that we're dealing with text and history, we've seen in the Naperville case where the anti-gun lawyers have tried to say there is no text and history of sales. Well, they're wrong. First off, let's go back and revisit Ezell. Ezell 1 and Ezell 2 in the Court of Appeals of the Seventh Circuit said there are ancillary rights to the Second Amendment that are built into the text. Things like training and remaining proficient. Then you also have the Illinois Firearm Retailers case, which said that there was a right to acquire. How can there be a right to acquire if there is no corresponding right to sell? And I would argue that along with maintaining proficiency, there's a corresponding right built into the Second Amendment to maintain a firearm in a working and operable condition. And so if we really want to tackle this stuff, we have to build on the foundation of Ezell 1, Ezell 2, and the Illinois Firearm Retailers case. Those all become pertinent into laying the foundation and the framework on the ghost gun stuff, because Illinois' law goes to possession. It goes to building your own guns. It goes to the state sticking their nose in places where it doesn't belong. We've, much as I disagree with the FOID card, we've had the FOID card, okay, and we're working to get rid of the FOID card. But so long as it's here, I've complied with your BS dictatives about doing the FOID card, going through the background check, and all you've said is no amount of FOID cards, no amount of background checks, fingerprints, whatever it is. And that's the point of it, is that no matter how many hoops we go through, no matter how much red tape we try to run through, it's never enough for them. They want their bans. That's all they want. They want to limit us to muzzleloaders if they can, and just call it that at the end of the day. I'm sure there's some of them that don't even want us having muzzleloaders. So with that, you've got the two sides of the coin with ghost guns here in Illinois. You got the federal issue, which is attempting to try to regulate frames and receivers at the commercial retail sale level and the way that they are manufactured and leaving the factory. And then you've got Illinois' law, which not only bans the sale or acquisition of them, but also the possession and or transport of them, which is all going to need to be litigated out. We've already had a court in Delaware throw out their ghost gun rule. We know that dismissal of that law, and the enjoyment of it is probably going to be taken up on appeal, and we'll see the same 21 rabidly anti-gun attorney generals that filed in the one Texas suit already to turn around and file here again. I think you're going to see that collaboration of those AGs being rounded up by the anti-gunners in order to file amici brief after amici brief on all the issues they don't agree with. So we'll have to wait and see how some of this stuff shakes out. It'll be interesting to see what the court does this week, if there are any motions filed in Vanderstock down there in Texas, and what that judge is going to do. So with that, that's just a kind of down and dirty tutorial on ghost guns in Illinois and the difference between what the feds are trying to do and what the state did, and where it's going from here. So, and a quick shout out to the Armed Scholar to give Anthony credit for the little clip it that I snatched off his analysis of the Vanderstock case. So, guys, pay attention to his page as well, Armed Scholar. I'll put a link down below. With that, guys, as always, we appreciate your continued support. Please hit that like button, hit that subscribe button, copy, paste the link to this video around to all the forums, blogs, and whatever else that you're engaged in, just to help spread the word. And like I said earlier, we're going to be working on hopefully some daily updates going on with what's going on with the lame duck session when it opens up on Wednesday with regards to their attempts to pass a semi-auto on a mag ban. So as always, thank you very much, and frag out.